Hello and good evening. Today we have a topic that is very interesting. And if you are married to a US citizen or you're going to be married to a US citizen in the near future, you should definitely stay tuned to our conversation today because we are going to talk about everything you need to know about obtaining a green card based on relationship, marriage to a US citizen. We'll talk about the process, the timelines, requirements, really break down what you need to know to get your green card based on marriage to your spouse. So for those of you that don't know me, I'm Yael Brudner. I'm an immigration attorney and I practice immigration law exclusively, representing clients all over the United States and throughout the world. Actually, our office is located here in Southern California, and immigration is what we do. In immigration, we specialize in marriage-based immigration, which is our topic for today. Okay, if you're new to our channel, please subscribe to our channel so that you can get more notifications about events just like this. And if you're joining us live, that's amazing. I'm so glad that you're here. Please feel free to write comments or questions as we go. And the good thing is that if you are watching this in the recording of this, it's also great. Welcome. Feel free to write your comments and I will try to answer them personally as I see them to come up. Okay, perfect. So let's jump into the topic and then I'll get to some questions, okay? So you're married to a US citizen or you are about to get married to a US citizen. What's the process? What does it look like? What do you need? What documents? What are the requirements? So every marriage case is break down to two parts. There's the petition part, and then there is your application to become a resident, to get your green card, okay? And depending on your situation, if you're here in the United States or you're outside of the United States, if you're here with a legal entry or you're here with a non-legal entry, the second part is going to change. Okay, the part where you're applying for the green card, that part is going to change. But the first part, the petition, is actually equal to everyone. So anyone that gets married to a US citizen is going to have to file a petition, and that petition is the I-130 petition. You might have heard about it. It's the foundation of your entire case, because if your I-130, if your petition is not approved, you cannot continue, you cannot get your green card. So it's crucial that you file the I-130 properly. And if you took a look at the I-130, on its face, it doesn't look like a very complicated application, but it is deceiving, you guys, because the actual form itself is not maybe a big deal because it really asks a lot of biographical information, a lot of questions about your name, your address, your parents' name, your employment for the last 5 years, any previous marriages, any kids, okay, biographical stuff. But really what's important with this I-130 is what you submit with it, what evidence you're including in this I-130 petition, okay? Because it's your responsibility to prove that you are eligible, that you have a bona fide relationship, a real marriage. Okay, guys, there's a lot of fraud in this field. I know I don't need to tell you guys this. You know that a lot of people get married to get a green card, right? And that's why everyone else that has a real relationship has a hard work to prove that they're a real relationship, right? The burden is on them. So you have to prove that you're a real couple. You have to prove that on paper, and you might even have an interview to determine the validity of your marriage. Okay, so that's the first step. First step is your I-130 petition. Now, the second part in the anatomy of these green card cases based on marriage is your application for the green card. Now, this is assuming that your petition was approved. Immigration already believes you, you're a real couple. They approve your petition. Now it's the next step. Now the focus kind of switches from the relationship to the actual applicant. And now immigration is looking at the applicant and asking, okay, are you qualified for the green card? Are you eligible to become a resident based on this petition? Now immigration is going to look into your background, your immigration background. Have you had any immigration violations? How did you overstay? Did you enter unlawfully? Looking into your criminal record. Do you have anything on your record? Have you ever been arrested before? They'll look into public charge. Are you able to provide will you be able to provide for yourself? And then they even look into medical considerations, right? So they will want to see that you are generally healthy, that you've had all your immunizations, and there's no reason to deny you this green card. Okay. Now, the second part, this application for your green card, for your residency, really can change logistically a lot. And you have to prove that you're eligible for this part too. So if you're here in the United States, right, and you're lawfully here, then you can apply for something called adjustment of status. Okay, adjustment of status is an option, just a fancy way. It's kind of how I say it, a fancy way to apply for the green card in the United States. So if you're here in the United States, you entered lawfully with a visa, now you're married to a U.S. citizen, you can proceed to apply for the green card here in the United States. Currently, right now, we're June 27, 2024, one of the best times to file for adjustment of status. We're seeing super quick adjudications. We just got a few this week that within 3 months got their green card. So it's kind of mind-blowing how quick it's going. If you're in that scenario that you are lawfully here, came in with a visa, married to a U.S. citizen. Okay. If you are here in the United States, married to a U.S. citizen, but you did not come in lawfully, okay? You came in unlawfully, and you only came in one time unlawfully, and you've been here ever since. So it's very common. A lot of people come in at a young age. They come in 6, 7, 8, 9, okay? And they stay here in the United States ever since, and now they're married to a U.S. citizen. So there are a couple of laws that come in play here. Basically, if you do not have a legal entry, you would have to go back to your home country to process the second part of your case. Okay. And you would have to go and apply for something called an immigrant visa abroad. And if you have not, if you've been here for more than a year unlawfully and then you leave for your interview, you also trigger a 10-year bar to return, which means you have to ask for a waiver of forgiveness. Okay. So if you are someone that is married to a U.S. citizen but entered the United States unlawfully one time, the way the law is written right now, you need to go ask for a waiver and then go back to your country for the interview and come back with an immigrant visa. Okay, that's the way the law is right now. Now, as of 2 weeks ago, there's a new suggestion. There's a new program that the Biden administration has put in place. It's called Parole in Place. Right? This program has not started yet. It's subject to start in a couple months, but it would be exactly tailored for those people that we just discussed that came in unlawfully one time and are married to a U.S. citizen as of June 24, 2017. Okay, so for those folks that were supposed to leave and do a waiver, then they would get a special route if this new Biden law goes through, where they would not have to leave and they would be able to do the process here in the United States through something called Parole in Place. Okay, so just to recap what we just discussed, green card case has two parts: a petition and an application for the green card. Petition is to prove that the marriage is real, that the relationship exists. It's the foundation of the whole case. But once that's approved, the next step is for the applicant to apply for their green card. And then can either do it in the United States if they entered lawfully with a visa, or if Biden's new program goes through, even if they did not enter with a visa and they've been married since June 2024, they would be able to do it if they've been here for 10 years. Okay. Let me jump into some questions that I'm seeing. Let me see right here. Okay, Tamika is asking, if you have a pending I-130, can I still apply for parole in place? How is that going to work with parole in place? Because you're going to have to do one I-130 and 485. Yes, so very good question. So assuming the parole in place new program goes through, right? We need to wait until that, is official. If it goes through, you actually can still apply for parole in place if you have a pending I-130. And then once your parole in place is approved, you would file the 485 at the same time. Okay, so basically the 485 is what is the adjustment of status application. That's the form number. So you would definitely be able to do it. And I recommend to do it if you otherwise meet the requirements, meaning you've been here for the last 10 years and you've been married since June of 2024 and you've entered unlawfully. Okay? Perfect. Andrew has a question. I did apply for the T visa, got my receipt and case number, but when I try to see the case online, it states that it doesn't show my case. Why? So sometimes for T visas and U visas, there will not be an update online based on case number. It's just due to the specific kind of case that it is. So it's not uncommon. But if you do have a case number, then you can call USCIS and ask for an update on the status of your case. Okay? Perfect, Tamika. Wonderful. Yes, if you meet the requirements, I definitely recommend to go ahead and file for the parole in place as soon as it comes up. Okay. So let's talk a little bit more about situations about this new parole in place program, because we've been getting questions all week, all last 2 weeks actually, about this new program. So let's talk a little bit about it and how it changes the possibilities if you're married to a U.S. citizen. So what are the requirements for this new program? The requirements for the new program are that you have entered the United States unlawfully, meaning if you've entered with a visa, it doesn't apply to you. And actually, if you enter with a visa, you don't need this program. Because remember what we just said in the beginning of the video, that if you entered with a visa, you can, and you're married to a U.S. citizen, you can apply right away. You don't have to leave the country. Okay? So you've been here, you entered unlawfully. You've been here for the last 10 years. So you've been here continuously since 2014. And then you are married to a U.S. citizen since June 17, 2024, and you do not have a disqualifying criminal record. Okay, those are the requirements. Now, if you are approved for the parole in place, then what you get is a 3-year let's say protection from deportation. You get parole in place valid for 3 years. It gives you protection from deportation. It gives you a work permit and a social security if you don't have that too. Okay. Now, parole in place is something that it's actually not a new concept. It has been a thing in the contents of military. So for military spouses, there's something called parole in place right now, and it gives you that legal entry that you need to qualify to apply for the green card in the United States. So basically, they're paroling you without going anywhere. It's kind of like how I explain it. They're giving you what you need to apply for your green card in the United States. So it's really, really beneficial for folks that otherwise would have to go back to their country, would have to ask for a waiver of forgiveness. It would most likely shorten the process for folks by potentially 3 to 4 years. A lot less expensive, a lot less risky, because even if you have a waiver of forgiveness, you still need to leave. It's not without risk, okay? Tamika is asking, how can you prove that you entered unlawfully? Right, so you would have to state that you were not admitted, that you did not enter with a visa. You would be asked that question. Immigration has sources to know and check if you entered with a visa or not, if you had a visa before. Let's see. Lucky, lawfully married to a U.S. citizen. Jump ship in 2006, no multiple entries or criminal record with joint bank accounts, utility cars, no deportation orders. So Lucky, are you asking if you qualify based on that? Or is it you're stating? your situation, right? So basically, if you've entered unlawfully, you're married to a U.S. citizen as of June 14, 2024, 17, June 17, 2024. You've been in the United States for the last 10 years. So you've been here in the United States since 2014. You don't have a criminal record. You've never been deported before. No multiple entries. No, we're talking about one entry at this point. Then yes, it definitely seems like you would qualify. We are waiting to receive more clarifications on the program. We don't know yet what the form is, what the application is, what's the filing fee going to be like, what kind of evidence would be required. So a lot is still missing. And, we're trying not to get everyone's, hopes up too much because it still has not been implemented. It hasn't started yet. So we have a big chance that this is going to be stopped by the courts. And we have a big chance that if it is approved and it does go through, then if we have a change of administration and, it might be canceled in January, right? So this is a very fragile program right now. My recommendation, what I've been telling to our clients is that might qualify for this is we're monitoring the situation and what can you do to prepare. We'll start providing guidance on what folks can do to prepare. So if this does go through, to quickly file for it before it gets canceled, right? So what can you do to prepare? You can start collecting evidence to show that you have a bona fide real marriage, show evidence that you've been in the United States since 2014. And that could be very time consuming. You would have the burden to show that you've been in the country in the United States for 10 years. So how do you show that? You go back for every year, every month, provide some kind of evidence, right? So pay stubs, tax returns, medical documents, if you've ever sent money outside of the country, if you got married during that time, if you had kids during that time, all of that is evidence that you've been in the United States. And my recommendation is really to start already and collect these documents or kind of start thinking about these documents in a way that you put them aside or you create files on your computer where you start uploading documents for every month of every year of the last 10 years. Okay. If you have any criminal record, if you've ever been arrested before, get your criminal records, get your court records ready. Do a background check to know exactly what's on your record because we don't know, maybe they will permit some kind of criminal record to be approved. Okay. With DACA, for example, the law says that if you can have up to 3 misdemeanors or 1 serious misdemeanor. So 3 less serious or 1 serious misdemeanor. If you have 3 misdemeanors or 1 serious misdemeanor, you wouldn't qualify for DACA, meaning if you have less than that, you would. So we don't know if for this new parole and praise program, there's going to be any kind of exceptions like that. Okay, Tamika is saying, so with DACA, I already have my social security. Will parole in place allow me to use the same social, or will they provide me with a new one? So you have DACA, you have you have your social, you have your work permit, which is great. You won't get a new social because you only get 1 social, so it'll be the same one. But it's still good for you because, and I still will pursue this program because DACA doesn't give you that lawful entry that you need. And parole in place would, right? And it kind of gives you protection, double protection. You have DACA, which gives protection from deportation and a work permit, and you'll have the parole in place program as well. So we don't know what's going to happen with DACA. So it's a very good idea to do both if both are available to you. Okay. You're welcome. Folks, if anyone has any questions, feel free to write them now in the comments and I'll try to get to them. Let's see. Okay, here's a question. If your parole in place is granted and your case is in removal proceeding, it's better to close it and adjust with USCIS or file with the court. Which one is faster? So we don't know yet what would be the policy if you're in removal proceedings and if you would be eligible for this or not. Okay, that's one of the things that we're waiting for clarification on, because you might not be qualified if you're in removal proceedings. So we're waiting to hear about that. Lucky is saying, oh, you also have a formal decree blessing the marriage. Wonderful. That's great. It's good. What, the most important thing, you said it's before, it was in 2013. Great. Start collecting all of this evidence. And if you're married to a U.S. citizen, you might already qualify to file the petition and get your case started if you haven't yet. Okay. Perfect, guys. I just want to mention one last thing before we end today. And again, if you have any questions, please feel free to write them. And if you're watching the recording of this, you can also ask questions. I promise to get back to you. I have to plug in a note about applying for something if it's available, because if you guys followed what happened with DACA, the DACA program started very similar to how, almost identical to how Biden just announced this new program. And this was 12 years ago. It was 12 years ago this month where the Obama administration announced about DACA, the DACA program. And ever since, the DACA program has been up and down, it's on, it's off. And right now, immigration is not accepting any new DACA cases because it's stuck in court. There's an injunction on the program by a federal judge that said, until we decide the legality of this program, immigration can't approve any more DACA cases. So if you already had a DACA case pending, you can still renew it. You can still get your work permit. You can have your social. You're protected from deportation. But if you did not apply for DACA, they're not accepting new DACA cases right now. So if this new program, Parole in Place, becomes available and you are qualified for this program, I want to encourage every single one of you guys, don't wait. File for it as soon as possible. Don't procrastinate. Don't wait to do it next month, or, you have to get it in. Because if it gets canceled, there might be a difference if you have your case pending or not. Similar to DACA. With DACA, they said anyone that their case is already pending, already had a DACA case, will keep renewing it, but new ones are not accepted. So there might be a difference if you have your case pending or not. We don't know. But the bottom line is, if you are eligible for something with immigration, file for it, because you never know what's going to happen if they might cancel this option. Okay. Tamika, I don't have a personal joint bank account with my husband. We do have a business joint bank account. It's not mandatory to have a personal joint bank account. There's nothing that's mandatory to have. It's really a totality of circumstances. You have to present the best case possible to show that you guys are married, you're a real couple, you're living together, you're husband and wife. You can be totally living together, married to each other, loving each other, have kids, but don't have a joint bank account. It's okay. It's just a matter of the more you can show, the better. Okay. Perfect. Well, folks, it was such a pleasure seeing everyone tonight. Thank you so much for your great questions. Feel free to like us on Facebook, subscribe to us on YouTube, ask us questions. I promise to answer them. And I'll see you next time on our next live.